Yes, sir.
Okay, thank you.
And have you reserved your time also for rebuttal?
I'm sorry.
Your time for rebuttal?
I will reserve some time, 5 minutes.
5 minutes for rebuttal. Okay.
And may I take my mask down?
You may.
I thought I saw that.
You may proceed for the appellant.
Thank you. May it please the court, my name is Sheridan Randolph of the Bradley County Bar, Cleveland, Tennessee. We're here on an alimony modification. The trial court had awarded alimony in futuro of $1,100. It did that on a finding that ex-husband was making, and that would be Powers, $185,000. I believe the court later determined that Powers had been making more at the time of that determination. Also at that time of the initial award, the court found that Appellant, Akers, was cohabitating with someone that is referred to in the record as Yahweh or DJ Yahweh, whose last name was Hawkins. I think that may have been a bit of a distraction through the trial and on the motion to modify later. So the initial award took into account that Miss Akers was cohabitating, and took into account that the Hawkins may have been contributing $900 per month at that time. In this motion to modify, evidence was presented to the court by Mr. Powers that his income had declined. If there is an order in the record, and I can cite to it, that does say that they both may have health problems. And I believe, if I understood, the termination of the alimony in futuro turned on the cohabitation, which Ms. Akers disputes, and on his Powers' ability to earn. So to take up some of the evidence that the court relied on in finding that Ms. Akers was cohabitating with Mr. Hawkins, Mr. Powers had employed a private investigator. I would call attention in the record, it shows when this private investigator named Corey answered an ad for Ms. Akers to take on a roommate. Ms. Corey did not testify, and I don't see that she was asked, but it's not in the record that she recognized the person who answered the door as the same person when she had visited previously and noticed someone washing a car in the driveway, that was the same person as Hawkins. So if Ms. Corey was trying to assert through her testimony that Hawkins resided there, what's missing is it's the same person she'd seen previously washing his car. Also, there's certainly, I think you can surmise from the record, that the young man washing his car was a different age from Mr. Hawkins.
Counselor, even if we discard the evidence of who was washing the car and whether or not that was Yahweh or someone else, a previous tenant, and even if we discount the things that this man said to the private investigator during the tour, don't we have other evidence of cohabitation, including the ad itself and the words of your client, where she talked about, we do this and we provide that, and indications that there was someone else living there that came directly from her?
So yes, there is such evidence, and Ms. Akers testified that she did that for security reasons, being disabled and living alone at that point in time. I do think that the record would show that these two maintained contact. I think there was some dispute about how much of his DJ property was in the home. I don't think the private investigator had she was able to look through the house. She didn't look through the main bedroom, so she didn't have opportunity. So we can argue that other indicia were not present, but maybe she didn't have opportunity to look there. And then it comes down to whose burden it might be to show that. It's unfortunately not, there are other things that could have been in the record as to why they were not living together, but I don't have that. Okay.
Counsel, excuse me for interrupting.
Yes.
Did the trial court make any credibility determinations with regard to the testimony?
I'm trying to recall if there was an explicit determination in a judgment. I don't remember a frank statement of that, but I took it, at least impliedly, that the trial court did not credit Ms. Akers' opinion or her statements that Mr. Hawkins did not reside with her at the time of the hearing.
Thank you.
Yes. So the argument then is that even if they were cohabitating, and Ms. Akers maintains that they were not, that was baked into the initial award of alimony and would not constitute a change in circumstances. Also, I point to in my brief.
Let me make sure I got that correct. So even if they were cohabitating, although your client maintained that they weren't, that would not constitute grounds for the initial change for alimony in futuro?
Because it was baked into the original determination. The court did make a finding at the time of the awarding of $1,100 that Mr. Hawkins was cohabitating with Ms. Akers.
Okay.
And Ms. Akers' position, per her testimony, is that that condition had changed and they were not residing together, and she did provide information for where Mr. Hawkins was in fact residing at the time. She cannot say that they were not in contact.
Okay.
So.
Mm-hmm. I understand at the time of the hearing, was the rental property, the space, or was that vacant, or was it occupied?
On the record, it was vacant, Your Honor. There was evidence that she had had two roommates, and if I recall, one had been a shorter term, one a longer term. The room was offered at $700, or if a tenant took two rooms, $1,000. And in the initial determination, when the $1,100 was initially, the judge found that Hawkins was bringing in $900 per month. So if it's $700 or $1,000 per month, if it's occupied today, which I have no information, but if it were today at those rates, that's in the ballpark of what the court had already, again, baked into that initial determination.
Okay.
Another point, quickly, is that in futuro, I think the judge converted it into insolito when he terminated, and that it shouldn't be terminated but modified, and if the modification is to zero, that's different from termination, and I think that might have been the proper remedy.
And based upon what do you feel?
I saw the look and I started trying to find my support.
And also, was that argument presented to the trial judge that it was solito instead of in futuro?
I don't think either party raised that issue specifically in terms of conversion. I think that perhaps it came as a surprise to Ms. Akers and her counsel that it was fully terminated. That may be about my time, I think. So, thank you.
Thank you. You have your rebuttal time. Yes, sir.
May it please the court. My name is Arthur Bass of the Bradley County Bar, and I represent the appellee, Neil Powers. In this case, Mr. Powers had alleged that there should be a modification of alimony based on material change circumstances. And essentially, these change circumstances were twofold. First of all, Mr. Powers presented proof that his physical condition, his health, had significantly deteriorated since the original hearing where the alimony was set, and that he was no longer physically able to do the kind of work that he did back in 2016 when the original case was heard that generated the kind of income that he had back then. Specifically, his health issues were that he had become insulin dependent because of his diabetic condition, and he was now having to wear an insulin pump. He had to wear a brace on his left forearm because of problems with the nerves and the use of that arm. He had a weight gain over the past 2 years before the modification trial of approximately 50 pounds because of changes in his diabetic condition. He had developed problems with his vision. He had cataracts, and in driving at night, he had double vision so that he was no longer able to operate a vehicle at night. So he had some significant medical issues that had arisen since the original hearing. In addition to that, he had also gone through job changes over which he had no control and which had considerably reduced his income. At the original hearing, when alimony was set, he had steady employment with a company named LoJack. He writes software. That's what Mr. Powers does. He was terminated from LoJack, and after that, he had to find other employment. He went to various people, usually working more or less short-term jobs, trying to fill in from that the income that he had lost when he lost his steady employment. And it did result in a significant change in his income. He had in 2016, his actual income for that year was $209,348. His income from employment in 2019 was $132,190. That's a 37% reduction in income. If we take what the court used, the court didn't have his 2016 income tax return at the time the hearing was held in 2016. The court made a finding that he would be making at least $185,000, and the court based the original alimony award on that. But even if we take that $185,000 as his income for 2016, going down to $132,190, that's still a 29% reduction in Mr. Powers' income. So he was struggling to try and pay the alimony that he had been ordered to pay. In fact, Mr. Powers testified that there were months when he had to forego his insulin in order to be able to pay the alimony. But as Judge Puckett noted, he kept the alimony payments up. Also, in order to make the alimony payments in 2018 and in 2019, he had to withdraw money from his 401k retirement savings. And in fact, in 2019, he drew out the last of that money, completely depleting his retirement. So, as the court noted, he would not have that to draw on going forward. The court was very concerned and did take into account, of course, that Ms. Akers was cohabitating with Mr. Hawkins, Darrell Hawkins, who was known as Yahweh. And as the court noted at the original hearing back in 2016, Mr. Hawkins, or Ms. Akers, denied then that Mr. Hawkins and she were living together. Ms. Akers, as the court noted back then, Ms. Akers testified that they had a relationship, but they had broken up. Well, here we are looking at the situation in 2019, and Mr. Hawkins is still there. He's in South Carolina now. At the original time, they were living in the local area in Tennessee. In 2019, she had been in South Carolina for, she said, approximately 3 years. And when this investigator, Danielle Corey, went out to the house, Mr. Hawkins was there. And there was no objection to this. He introduced himself as Yahweh to the investigator. Now, as has been noted, this investigator did go out to the residence on 2 occasions. The first time, she did not actually go to the house to meet anyone, did not have contact with anyone. She just made observations. That's the first time she went out. And on that occasion, she did take the pictures of the person washing the car. And she did indicate that that was not the same person as the person who introduced himself as Yahweh when she actually went out and made contact with Ms. Akers. Ms. Akers had placed ads for a tenant in 2019. And in all of these ads that she placed, everything was in the plural. We, our. And when the investigator, Ms. Corey, responded to these ads, she asked Ms. Akers about her use of the plural. And Ms. Akers told her that we'll explain about that when you come out to see the place. So when she went out to actually see the place, posing as a tenant, a prospective tenant, it was Mr. Hawkins, Yahweh, who was there at the door and introduced himself as Yahweh. But Ms. Akers and Mr. Hawkins showed the downstairs portion together. Downstairs is where the master bedroom is located, also the kitchen and some common areas. Also a workspace, which Ms. Akers herself identified as Mr. Hawkins' workspace. Upstairs, there were 2 bedrooms. Those were the tenant areas. And Mr. Hawkins took the investigator upstairs and showed her that upstairs area, which was vacant at the time. Now, in seeing the downstairs spaces, Ms. Akers warned the investigator that if you come to live here, there may be a little noise at night because Yahweh, Mr. Hawkins, plays music at night, but we'll try to keep it down. She also, in showing the kitchen area, said, you won't have to worry about us getting into your food, showing that you have your area, we have ours. So even if it hadn't been for the admissions that Mr. Hawkins made about his living arrangement, mainly that he was living there with Ms. Akers, even if it had not been for that, there is still plenty of evidence to indicate that there was cohabitation. But I think the court was correct in allowing the investigator to testify to what Mr. Hawkins said. There is the statute on alimony in futuro, 36, or I'm sorry, I'll come to that later. What I meant to talk about was the rule of evidence, 803 1.2, which is admissions by a party opponent. And there are two sections there worth looking at. Under 803 1.2, there is C, which makes an exception to hearsay for a statement by a person authorized by a party to make a statement concerning the subject. In this case, Ms. Akers had explicitly authorized Yahweh to show the upstairs and to make whatever representations were necessary to Ms. Corey to try to attract her to rent the premises. And then D is similar. It makes an exception for a statement by an agent or servant concerning a matter within the scope of the agency made during the existence of the relationship. Well, Ms. Akers had delegated the showing of the upstairs and other areas to Mr. Hawkins. Clearly, he was acting as her agent in this regard in trying to rent the premises. So I think the court was correct in allowing all of the statements that were made by Mr. Hawkins to also come into evidence. And it's just clear as can be that there was cohabitation. Judge Puckett makes the point that they were together. He made a finding that there was cohabitation when they were together in Tennessee. And now that she's moved to South Carolina, Charleston, Mr. Hawkins is still there. So, not only do we have these reductions in income, deterioration of health on the part of Mr. Powers that make it virtually impossible for him to continue to pay the alimony as ordered, but also there is in the statute 36.5.121 F2B, there are two things. First of all, if cohabitation is shown, then there is a presumption that, or if cohabitation is shown and the third person is contributing to the recipient, that the recipient does not need alimony is a presumption. Also, there is another one, that's little I. 2I says that if a third person if a person is receiving alimony and a third person is there cohabitating, there is a presumption that the recipient does not need alimony. So either way, whether that person is contributing or whether he is receiving, if there's cohabitation, it raises a presumption that alimony is not needed. Under case law, and this is cited in the brief, it's Wright versus Quillian, 83 Southwest 3rd, 768 at 775. Under case law, once cohabitation has been established, the burden of showing that there is a need for alimony shifts to the recipient. In this case, instead of presenting proof on whether or not she still needed alimony, even with the cohabitation, Ms. Akers just stood by denying that Darrell Hawkins lived there with her. And because the burden was on her to rebut the presumption that she was no longer in need of alimony, Judge Puckett made a finding under the statute that, in fact, she had no need. And the court has great authority in a modification case. TCA 36-5-121 F2A says that an award of alimony in futuro shall remain under the control of the court. The court can increase it, decrease it, or terminate it, or otherwise modify it upon a showing of changed circumstances.
Thank you. Your rebuttal, sir?
I would note quickly that there were no medical records, and that the court had noted previously that the health issues, or at least some health issues, were foreseeable. That's in Record Volume 1 at 14. It's also, I believe, in page 20 of my brief. The income amount, so Powers' income should be sufficient to continue paying alimony. There is a case that I've cited where a husband's income of $4,285 per month was sufficient to sustain an award of alimony in futuro of $1,200 per month. That's Oaks v. Oaks, a 2007 case from the Tennessee Court of Appeals. It's reported. At the time of the divorce, the court found that Ms. Akers made $20,000. It later recognized that she was disabled and not likely to ever earn any more money other than her disability. There is in the record that she had been working towards counseling degrees and certification, but the court found that that wasn't likely to ever happen, and her increased disability made that she couldn't it was hard for her to get out of the house, which is also why she needed someone to help her show the second floor. If she was not getting contribution from Mr. Hawkins, then she can't, I don't know how she would show a hole. There's nothing there to show. She denied it. I mean, that is a presumption. I think Ms. Akers' stronger position is that this is not a change in circumstances that would allow the modification. And there was one other, I couldn't find my citation earlier, but I did quote from Weiser v. Weiser, a 2015 case that, I cited to that, and that case is quoting a 2004 case, Woodall v. Woodall. This is on page 20 of my brief, and it says in part that even if presumptions of support and lack of need arise and are unrebutted, the court's remedy is to suspend all or part of the alimony obligation, that's in quotes, and not terminate the alimony. And they cite to the statute 121F2B. So Ms. Akers is asking that her alimony be reinstated. I don't think the proof preponderates that he is unable to pay the amount that was awarded. Her medical condition has also, I mean, if you credit that his has on his testimony, then also by her testimony, she is also in a worse state medically, and she needs more support, but at least it seems from the record, we argue that Mr. Powers is able to continue to pay what he had been paying. His financial position was partly of his own making by his own testimony. He had 15 credit cards, most of which carried a balance. He was making payments on an RV. He was cohabitating with two persons, I think in Massachusetts, and maybe shouldering some burden burdens there that were at his discretion. So Ms. Akers argues that he has the means to pay the alimony that she had been receiving. His medical conditions were at least partially foreseeable. His income was sufficient under case law, under Oaks v. Oaks, to support what he was ordered to pay the first time around. And as to whether Hawkins was living there or not, Ms. Akers did deny that, but even if she doesn't overcome the presumption, that was baked into the first. It's not a change in circumstance, and all evidence seemed to show that she's not in any different position than she was at the first. I mean, at worst for her, and for sake of argument, she's not in any worse position or better position in terms of the income, because even if it's rented out, it's $700 to $1,000, and she does not, she denies that Mr. Hawkins, while they were certainly still in contact, was cohabitating, and we don't think the evidence supports that he was cohabitating. Thank you.
Thank you, sir. Your case has been submitted to the court. You should receive our opinion within a due course of time. I want to thank you both for your presentation.
Thank you, Your Honor.
The attorneys may be excused. If there's nothing further, Madam Clerk, will you please recess the court?
All rise.